Who's up?
May it please the court. My name is attorney Ralph Brooks. I represent the appellant petitioner in this case. I'd like to reserve at least 3 minutes for rebuttal.
Okay, thank you.
The circuit court order below that's on review here today expressly did not review two important claims on their first tier as of right certiorari review. First, the circuit court expressly did not review petitioner's claim number 2, which is related to claim number 6. The board violated the Sarasota County Code of Ordinances that establishes a specific mandated procedure requirement for adopting a site-specific critical area plan, which I'll call a CAP, for a specific development project that applied to only the applicant's property and no others in the county. Second, the circuit court expressly did not review petitioner's claim number 4, that the board failed to apply the land development code approving additional density, height, and a multifamily use in the commercial general CG zoning category that requires a special exception, which includes a special exception public hearing and specific special exception findings that shall be made by the board with regard to this additional density, height, and multifamily use. These are both very clear procedural requirements that are built into the code, which have the essential requirements of law and are clear principles of law.
Well, let me ask you, because that sounds like an interesting procedural complaint, but if the procedure attending what would be a legislative act was improper, isn't the proper vehicle to challenge that improper procedure a deck action and not a cert petition?
Your Honor, the Siesta Promenade CAP, the Siesta Promenade rezoning, which included the approval of this additional height, density, and multifamily use, and its special exceptions, they're all quasi-judicial actions. The Siesta Promenade site-specific CAP is quasi-judicial and is properly reviewed by certiorari because—
Right, you're talking about the ultimate approval of the CAP, but earlier your argument was, well, the stuff they did preceding that ultimate determination, they didn't give the workshops, they didn't do the public notice like they should have. That sounds like it is inherently a process challenge to that kind of determination. Why isn't that properly brought as a deck action, not a cert petition?
You can bring under certiorari procedural due process claims and also essential requirements of law claims.
You can, counsel, but isn't it an extremely uphill climb? Second tier cert, I mean, the case law basically says for all intents and purposes, you know, the previous court ruling is the end of the line. And in order to get second tier cert, there's a very substantial showing that you've argued due process. And I'm going to ask you to address that in a minute, because I have a hard time seeing how you were denied due process. It sounds like your client was at every hearing that occurred. But you also got to demonstrate that the order violated a clearly established principle of law, resulting in a miscarriage of justice. So I need you to address that too. So my question to you is, drill down on the due process for us, and then drill down on the miscarriage of justice. And I'm sorry to give you two like that, but those are the two key things for me.
Okay. Let me hit these as I can, first with some law and then go into the facts. The Florida Supreme Court in Allstate versus Calacamanos held and opined that this second district Court of Appeal has in the past historically been perhaps too narrow in its interpretation of what is clearly established law. And clearly established law can include statutes, case law, and ordinances which are adopted as general law by the county and have the force of law.
Pretty much anything is law, right? But it's got to be do so and to create a miscarriage of justice from the standpoint of your client.
So my client
realistically think nothing would ever be built on this property?
No, that's not what this case is about. We're not asking you to call balls and strikes or even get to the merits of the decision as to whether the site-specific cap should have been approved. The Florida Supreme Court in Snyder was very clear, and subsequent cases, GBV and others, that quasi-judicial actions are those that affect a specific site, one property, with one developer for one application, which is what happened with this site-specific Siesta Promenade cap. This is not the case that was cited by the respondents, Sarasota County versus Carb, which involved 5.5-mile corridor plan with over 179 acres and 48 separate different landowners for a corridor plan that was prepared by the county itself. This was a site application.
Is that how you distinguish between what is quasi-judicial and legislative? If it's a really big project, it's legislative. If it takes more than 100 acres, if it's just kind of big like this one, then it's quasi-judicial. I mean, help me out here, because it does seem like this cap process kind of has features of both legislative and judicial. So help me out. You have, okay, your argument assumes it's quasi-judicial. You put it in that silo. How did you get there? How did you put that into the quasi-judicial silo?
Yes, Your Honor. There are many different types of caps under the Sarasota County Cap Enabling Ordinance 1662 and the regulations. There are corridor plans, there are sector plans, there are town and village plans. Many of these plans are prepared by the county in conjunction with many different landowners. This particular cap is by one landowner on one parcel for one particular development. Snyder says that actions affecting a large portion of the public, many property owners, are legislative in nature, where a policy application to a specific limited number of persons or property owners are quasi-judicial in nature. In this case, we're only affecting one parcel. CARP had 48 parcels. This own Second District Court of Appeal made the analysis in CARP that said 48 owners was a fairly substantial number of property owners, and it affected a large area, 179 acres. Therefore, that corridor plan for University Parkway, 5.5 miles of it, was in fact legislative, implying that if you only affected one property on only 23 acres, University Parkway corridor was 700 times bigger than this property. It's just one property. That this would then indeed be quasi-judicial. We were entitled under the case law to first-tier review in certiorari of quasi-judicial actions that did not occur below. The judge below mistakenly thought that the special exception was somehow approved by the cap. The cap does not say that. The Land Development Code doesn't say if you have a cap, you don't need to have a special exception. Snyder, the Florida Supreme Court, was very clear and expressly called out rezonings and special exceptions as quasi-judicial, and the rezoning that was approved contained Exhibit A that had this additional height, this additional density, and additional use that require a special exception by the Land Development Code. That should have been reviewed by the court below, and the court said they would not address it because they were confused and thought that this was subsumed within the cap and that the cap was legislative instead of quasi-judicial, which it is in this case.
Mr. Brooks, I just have an observation. In 2005, the property was purchased. The Sarasota County FLUM or FLUM was amended. So this property is automatically eligible for upzoning. So it's no secret what's going to happen on the property. But let me just say this. We read these kind of cases all the time. I will commend your client and the residents on how they handled this. They held everybody accountable. They were polite. They were professional. Sometimes in other cases it goes south, but in this particular case, I commend your client. But let me just say this, because it's a 4,000 or 5,000 page record, but what we were able to glean from it is the cap appears to be a planning tool that's a bridge between the comp plan, land development regs, zoning regs, and everything. But it also clearly says the adoption of a cap is not a grant or a guarantee for rezoning or development, and it doesn't have the effect of permitting or prohibiting development of any property. So if that's the definition of the cap plan, that seems to be legislative. That seems to be a fluid type of tool that depends on the unique nature of each piece of property. This doesn't appear to be a fixed regulation that's going to apply to every piece of property, no matter the unique nature of it at all. But let me just add this, because I read the order very closely. So even though the court did not review 2, 4, and 6, finding it legislative, if you look at the court's articulation of its findings in Claim 8, this court found that CAP was properly applied for and approved. Also, that traffic height, proposed buildings, and buffer zones were considered, and that even the October 2016 public hearing was continued based on the public's comments rather than the county not having their balls in order. It was based on the public. So it appears to me that this particular developer was put under some screws to get things right. This was modified multiple times. So in Claim 8, even though you may claim that the court made an error, and maybe this was quasi-judicial, arguably you say it is, but the court did make the findings that the procedure was followed and that there was competent, substantial evidence to show that this was compatible, that this met all of those factors that you see in CAP, all the factors that you see in the comp development plan and the land development code and the zoning code. So I'm trying to find here, let's say it is quasi-judicial. Where is the miscarriage of justice if in this particular order, the court considered everything and found it to have been done properly and that it was properly applied for and approved?
The miscarriage of justice comes from the failure to adopt the CAP in the right steps in the right order.
But how are you prejudiced in that?
Because
let's say they did it backwards, but the ultimate conclusion is it was done properly, whether 4 was done first or 1 was done first or 2 was done first. I'm trying to find the harm here.
If I might have 1 minute, Your Honor. The CAP process requires the establishment of a CAP boundary and impact area. Then that is supposed to be approved, but was not approved, was continued by the Board of County Commissioners. Then after the CAP
to expand the scope of the boundary, they addressed the boundary and they continued it because of your client's comments.
Once the boundary is established early in the process along with the impact area, there's a required public workshop that should be held before the CAP is prepared and before the Planning Commission. That did not occur. That would have allowed us to assess the impacts of the Siesta Promenade on areas like Siesta Key. It's very important that this court realize that this development is large. It's at the very southern bridge to Siesta Key, yet the impacts to Siesta Key were not mentioned even once in the traffic impact analysis or in the respondent's brief. The Siesta Key Association filed a motion to file an amicus in this case, and the court denied it, even though they have been trying to participate. This is a procedural case. It's not a merits case at this point in the second tier review, but it was quasi-judicial. And we had a first tier right to review in the lower court that we did not receive. It's clear that the applicant and the county failed to meet the procedural requirements of both not only the CAP, but the special exception that's required in the CG rezoning. If, as Judge Sleet points out, the CAP is not a development order and doesn't give development approval, only the land development code and rezoning can do that, then the rezoning and its lack of special exception approval for the height, the density, and the additional use should have been reviewed by the court. We did not receive that review, and this case should be quashed or remanded for that review. It's a case of the county failing to follow its own procedural requirements, not once, but twice. Contrary to the opinion of the respondents, there is authority in Florida Supreme Court cases like Omnipoint, Dania, and Valiant for you to review the lower court's failure to review the quasi-judicial CAP and the clearly quasi-judicial rezoning and special exception requirements. The third district 2 years ago recently reaffirmed in Alvey versus North Miami Beach, as cited in the prior case of Auerbach, the law will not and cannot approve a rezoning or government action adversely affect the rights of others that is based on no more than the fact that those who support it have the power to work their will. As they said in Auerbach, this court is not mere legal potted palms that must sit by idly while the county ignores its procedural requirements and while the circuit court fails to grant the first tier as of right certiorari review that we were entitled to. I think the court has asked a lot of questions that I will attempt to address and put together some additional answers in rebuttal if it's permitted, Judge Morris.
Okay, well, you're right at the 15-minute mark. You wanted to go to 17, but you can stop here if that's your choice, and you'll have 5 when you get back, if that's what you want to do.
Thank you.
Okay, all right. Mr. Brannick?
Good morning, Your Honors. May it please the court, I'm Steve Brannick of Brannick, Humphreys, and Berman, representing the respondent Siesta 41. I'll be splitting my time equally with Mr. Pierce from the county. The court is obviously well familiar with the very tough standard that applies in a second-tier cert proceeding, but I think there are 2 observations I want to make about that standard. First, any factual disputes have been settled. This court does not look at the facts even for competent substantial evidence, and that's important because all of the observations that Mr. Brooks made in his brief and today about traffic impacts and compatibility, those were settled in the first-tier certiorari proceeding. This project was the subject of very careful study. The project was supported by the facts. They made arguments in the first-tier certiorari proceeding below that there weren't facts to support the project, and the trial court disagreed. So those facts are settled. The second important point is a point that a couple of you were mentioned in your questions, which is that it's not enough just to show an error, you have to show a miscarriage of justice. And this is one of those cases that even if there was a harm here, there was no foul. There was no showing in this case that there was any harm caused by whatever the technical procedural missteps that they allege, and we think didn't exist at all. So let me turn to their specific arguments. First, they argue about the special exceptions, that the special exceptions weren't dealt with. First, they waived that argument below. That wasn't raised by the petitioner in front of the Board of County Commissioners. So just like in any other appellate proceeding, if it wasn't preserved below, it's not properly before this court. Secondly, the trial judge was correct to say that there was no jurisdiction here because this project was proved through the CAP process, and the CAP process is legislative, and that means if there are procedural problems in connection with legislative action, those procedural problems are dealt with in DEC action, and they're not appropriately raised in the context of a certiorari petition. So the big question here then is a CAP legislative or quasi-judicial? And clearly a CAP is legislative action. The law is settled in that regard. This court in the CARP case, looking at another critical area plan relating to Sarasota County, determined that a CAP was legislative action, and it makes sense. This was quintessentially policy making by the board, not the implementation.
Oh, but what about your friend's argument? I mean, it's quintessentially policymaking for one owner, one project on one parcel of land. I mean, there is at least an intuitive appeal that when you're talking about adjudicating the property rights or determining or declaring the property rights of one person or one entity for one project, one parcel of land, it sounds more like you're judging, less like you're legislating. Help me out with that.
Sure. Well, a couple of observations. One, you could say it's one parcel, but we're talking about the one quadrant in a major intersection. It could just as easily have been owned by 50 people as opposed to one person. So I'll disagree a little bit with the premise of your question, but even more importantly than that, the coastal development case from the Florida Supreme Court tells us in the context of comp planning that the question in terms of deciding between legislative and quasi-judicial is not the size of the project, is what was the Board of County Commissioners doing? Was the Board of County Commissioners implementing policy, or was it making policy? So the Supreme Court tells us in the coastal case that even a comp plan amendment that relates to just one small piece of property, just one lot, is still legislative because comp plan amendments are by their very nature the making of policy, not the implementation of policy. So the Supreme Court was very clear in the coastal case, which we discussed in our brief, that it doesn't matter the size of the project. What matters is what the county commission was doing. So I think it's important to understand exactly what the CAP process is all about, because there are a number of ways that a Board of County Commission can make policy. One, of course, is through the comp plan. That's the constitution that governs everything. Another is through the zoning code. You can set up a zoning district and you can say, here's what development is allowed in a particular zoning district. The problem is that a zoning code is often a very blunt instrument. If you look at the Sarasota County zoning code, it's 13 pages for commercial general. So there are a whole host of different things that you could put in the commercial general zoning code, many of which are far more intensive than this multi-use development that was put into place here. And so because of that, the county has adopted this CAP process, which says, for a particularly important piece of property, like the university corridor or like an important intersection, the CAP process allows the Board of County Commissioners to roll up its sleeves and say, look, we're going to decide what sort of development is appropriate on this particular important piece of property in the county. This was a big opportunity for the county. This was a long time mobile home park. And so this is kind of a movement away from old fashioned Sarasota to modern Sarasota. And so there's a real opportunity there. So do you put a Wawa, the county commission, along with the developer to decide exactly what sort of development is appropriate? What do we?
Everything that you're saying is also always got to be balanced against that backdrop that ultimately we're talking about affecting someone's private property rights.
Right. And ironically, I think they're complaining about a process that was far more intensive and far more, and which gave far more scrutiny to this particular project than just a rezone would have. I mean, they, as one of you pointed out, they were already entitled to far more intensive development just because the comp plan already says that this is going to be commercial general. So instead of just upzoning into something very intensive, we have a partnership between the county and a developer through the implementation of a policy that you end up with a far more appropriate development that balances the rights of the landowners that are close by, the rights of the developer, and you end up with something that I think Sarasota County is going to be proud of going forward. So this is clearly legislative, not quasi-judicial. We also talked about in our brief, and I'm not going to spend time on it today, but I think Mr. Brooks is also wrong in his premise. If you look, the comp plan in Sarasota County specifically says that a CAP can deal with density. The zoning code 6.10.1, which we cite in our brief, also says that height and density can be dealt with through a CAP. So there's no conflict with the code. But I think even the big practical problem they have, though, is they can't show any miscarriage of justice, even if everything they said was right, even if this were quasi-judicial, and even if they somehow had committed some procedural missteps. What is the difference here? They have not said, to your honors, they didn't say it in their briefs, they can't say it here today. What did the county not study that it was supposed to study? What did the county not do that it was supposed to do? Through the CAP process, it looked at everything that you were supposed to look at in the context of a typical special exceptions analysis. Everything that needed to be done was done. They haven't identified anything that wasn't. So there was clearly due process provided to these folks who were participating in every step of the way, and clearly no miscarriage of justice, because at the end of the day, as we know from the competent substantial evidence that is in the record and that the trial court found in the record, that this study was done properly and that there's evidence in the record to support what happened here. So for those reasons, we think that the judgment below should be affirmed. I will just note that we have a standing argument as well in our brief. I'll just rest on the arguments we made in the brief unless the court has any questions about that. Otherwise, I'll defer the rest of my time to Mr. Pierce.
Thank you.
Thank you, Mayor. Please the court. My name is David Pierce. I'm an assistant county attorney, and I would like to echo the arguments that have been made by my esteemed colleague, Mr. Brannick, regarding the second prong of the standard of review. And as pointed out, by you, Judge Sleet, you're looking at a question as to whether there's a miscarriage of justice. And I don't know how you could find a miscarriage of justice when the circuit court applied the correct law, which is the precedent from this court, which is CARP. And the CARP decision did involve the University Parkway Corridor Plan. It was a 5.5 mile stretch, from US 301 and I-75. We readily acknowledge that. 179 acres of property and 48 parcels. But as pointed out by Mr. Brannick, the coastal development of North Florida case, which dealt with a small scale comprehensive plan amendment, involved a situation where it was a single owner. It was a 1.7 acre parcel, and that was found by the Florida Supreme Court in 2001 to involve a legislative act, despite the fact that you're talking about one owner and a small area of property. And so I want to drill down, and Judge Lucas, you asked about looking at, well, why is this not quasi-judicial? Why is it legislative? And in the CAP ordinance itself, there is the exhibit that describes all the different things that the Board of County Commissioners was looking at in deciding what to do with this particular major intersection, which is at US 41 and Stickney Point Road. It was the formulation of policy. It wasn't just a simple rezone. It wasn't a simple special exception. It was a mixed-use development. There was a specific maximum number of dwelling units that were placed on this particular property. There was a specific maximum amount of retail and office space. There were 5 different block units within this 23.8 acres. And the height restrictions through the legislative process were restricted within each block. It basically was a step-down process from the interior of the project towards the exterior where it abutted against residentially zoned districts. Additionally, through the legislative process, the board set specific buffer areas between abutting streets and residentially zoned districts. Most importantly, as part of the legislative process, the board specifically included provisions regarding affordable housing units. And they specified the timing thereof, income eligibility requirements, and more importantly, the establishment of administrative agency to provide annual monitoring of the affordable housing component. The creation of that administrative agency to administer that affordable housing requirement is quintessentially a legislative process. Additionally, the legislative process set landscape buffering requirements, pedestrian plans for roads and sidewalks, open space requirements, specific building design standards, traffic calming, and transit requirements. So this was not just a simple rezoning or a simple special exception process. It was planning. It was the formulation of policy, not a quasi-judicial act as the petitioner would contend. And as outlined by Mr. Brannick, there was no need to go through a special exception process for either additional density, building height, or multifamily uses. And as spelled out in the county's response, there is the comprehensive plan policy, future land use policy 1.2.15 that says, quote, a critical area plan is required for mixed use developments requesting residential densities above 13 and up to 25 dwelling units per acre. So the comp plan recognized that you can have additional dwelling units or mixed use developments up to the 20 that was allowed through this specific legislative process. Additionally, as cited by Mr. Brannick, section 6.10.1 of the zoning regulations allowed densities of up to 25 units per acre in a critical area plan through that process, which includes mixed use development within a commercial center, which this is. And so the zoning regulations specifically recognized that as a matter of right through the critical area planning process. And that same section 6.10.1, specifically note 3 of the zoning regulations, also allowed a critical area plan to set maximum heights for development.
Let me ask you this, Mr. Pierce, because you keep using the term that a CAP plan must be used or must be applied. And I can understand Mr. Brooks's argument if you're saying that this CAP plan, which is the bridge between all other agencies, regulatory agencies, must be used, it sounds like that's an implementation as opposed to the formulation of policy. Do you understand where I'm coming from?
I understand where you're coming from.
So my understanding of CAP is, even though it must be required, the county and its staff must have some discretion to adjust a plan and formulate a plan and modify it for a unique piece of property.
Well, that
it appears to
discretion,
me throughout this entire process, this development ended up not being what Siesta 141 really wanted. It was even modified at the final hearing, was it not?
it was, Your Honor, and that guidance is limited by the CAP procedure ordinance. But the specific, again, the CAP ordinance itself was legislative through all the different components that I've specified here today.
Well, it just seems to me that if you've got a tool like that, county agencies should have a level of discretion when implementing it or using it.
Specifically, the board would have that discretion because you're talking about an ordinance of equal dignity to the CAP procedure ordinance that the board had previously adopted. And that discretion, again, goes along with dovetails into the last argument that has been provided by the petitioners in this instance regarding the boundary, that specific boundary area and the procedure plan. And specifically, there's a provision in that CAP procedure ordinance that says, quote, the board may approve any subsequent changes to the adopted boundaries during a regularly scheduled public meeting. So even the CAP procedure ordinance recognizes a certain amount of discretion and how the board goes about in executing its legislative process to set a specific cap for the Siesta Promenade Critical Area Plan. And again, going to the last question as to whether or not there's some sort of prejudice that's going on here, you had the original hearing back in October of 2016 regarding the boundary process. And there was no change in the specific study area boundary. The 23.8 acres remain the same between October 2016 and December of 2018. What did change, as you were correct, Judge Sleet, is that there was an expansion of the scope of looking at the impacts and what's called the impact area boundary. It's a separate boundary, and the board, through the scope of work, basically expanded what the board was looking at and trying to decide whether it was appropriate to enter into this critical area plan for Siesta Promenade or not. So how was the petitioner prejudiced by looking at additional things between October 2016 and December of 2018? And for those reasons, we'd ask that the court deny the petition. Thank you.
Thank you very much. Mr. Brooks, you have 5 minutes.
Sir, you're on mute.
Thank you. Under the CAP enabling ordinance, which allows the applicant to apply for a CAP and the county to review a CAP, there's a sequential mandated series of events that are depicted graphically in a flow chart that's contained in Figure 1 of the ordinance. It's reproduced in our petition on page 22 and 23 and in our reply. Procedurally, first, the CAP boundary, along with the associated impact area, must be approved early in the process. That did not happen in this case. The impact area is defined as the land area and systems within and outside the boundary of a CAP study area, which may be affected by the development. Only by first approving the CAP boundary impact area can we logically develop a scope of work for the studies on the impacts of the development. In this case, the CAP boundary and its associated impact area were not approved until the very end of the process at the final hearing, when the board held one massive consolidated public hearing and approved the CAP boundary, the rezoning, a special exception for hotels, but did not require a special exception for height, density, or multifamily use, and then adopt the rezoning to CG that had the concept development plan attached to it that had all this additional height without having the required special exception. Now that was done in one consolidated public hearing, all at the very same time, giving each person 3 minutes to comment on the myriad of applications that were before the board, all in that 3 minutes at one night and one hearing. How can a cap impact study be prepared unless the impact area has first been established? By not having the approved cap boundary and impact area and the required participation workshop before preparing the cap, it was not possible to influence that decision and participate fully in the process. This is not just any other commercial strip mall in any intersection on US 41, as it was characterized by respondents. It's a critical area in Sarasota and should have been treated that way. The Florida Supreme Court in Snyder not only addressed the quasi-judicial issue, but it also addressed the burdens. It says the burden is on the applicant seeking approval of a rezoning and special exception to demonstrate their application complies with the procedural requirements of the applicable ordinance. This failed twice. It didn't meet the procedural requirements of the cap enabling ordinance, and it also did not meet the requirements of the special exception public hearings and mandated findings that the Land Development Code requires the board to make to approve special exceptions that would increase height, density, and multifamily use. Just because they were in the cap does not then require or approve them. The cap does not say that they're not required to get special exceptions, and the code does not say that caps are not required to also obtain special exceptions. Now, the cap is quasi-judicial because what are we doing? We're taking the Siesta Promenade cap on one side of the table, and we're comparing it to the cap enabling authority that allows you to adopt a cap on the left side of the table. It's prepared by an applicant, the applicant seeking approval under the cap enabling ordinance. That's the application of the previously adopted legislative policy. Simply because the county retains the discretion to say no doesn't mean that this Siesta Promenade application for one development on one property owner's land affecting no one else isn't a quasi-judicial action that should have been reviewed. And clearly, the rezoning and special exceptions have been acknowledged by the Florida Supreme Court as quasi-judicial, and the failure to obtain those special exceptions should have been reviewed as a mistake in the rezoning concept development plan that included that additional height, density, and use without going through the special exception process. Also, with regard to the quasi-judicial nature of the cap for Siesta Promenade, the hearing itself, the character of the hearing was quasi-judicial. It was lumped all together. The concept development plan for the cap and the rezoning are the same. It was lumped together with the special exception. It was all conducted at one time. They swore all the witnesses in under oath, which they do for quasi-judicial, but not for legislative. And they took ex parte disclosures by the commission, which they do for quasi-judicial, but not for legislative.
Mr. Brooks, you've got 10 seconds.
We would ask that you quash the decision below because the circuit court did not review the cap as a quasi-judicial action and did not review the rezoning and special exceptions of clear quasi-judicial actions for the special exception requirements. If we do not uphold these requirements, the trust in law by the public is eroded and the code requirements are ineffectual. Thank you.
Thank you, sir. I appreciate it. I thank you both. This case is very interesting, well argued, well briefed, and we're grateful for your efforts. It helps us a lot. Have a good day. We have completed our docket. We are adjourned to deliberate these cases. Thank you all very much.